Yes, continuing our theme on retirement, we now have a presentation from Marilyn Collister. She is the Senior Director, Legislative and Regulatory Affairs for Empower Retirement. She is an employee benefits attorney specializing in governmental employee-sponsored deferred contribution plans. She has co-authored the 401k Answer Book. She's a contributing author of the 403B Answer Book, author of Focus on 457B and other defined contribution publications. She's a frequent speaker on issues impacting employer-sponsored retirement plans, including the fiduciary responsibility for the employer. And I think Todd Williams, also with Empower, has a few words to say with you this morning. So please welcome Todd and Marilyn.
Back, down and up, or?
Down and up, yeah.
Okay. Okay.
Good morning. Thank you all for being here. It's our pleasure to be with you this morning. Thank you, Lori. Many of you already know me. My name is Todd Williams. I'm with Empower Retirement. I serve exclusively on the state of Indiana's Hoosier Start Deferred Compensation Plan for Indiana's state and local government employees. Many of you in the room are already participating in Hoosier Start, so we've had a chance to meet. For those of you that haven't, though, it might be nice just to know what the relationship of Empower Retirement is to the state of Indiana's plan, being that we provide the record keeping and the education of all state and local government participants that are currently in the plan saving for retirement. So it's really a pleasure to have someone from our home office, Empower Retirement, coming in all the way from Denver, Marilyn Collister, to come out and speak with you this morning. We do have a couple things at the Hoosier Start booth in the back. There is Marilyn's Focus on Fiduciary booklet. This is a really helpful guide and a nice complement to today's presentation. So if you'd like one, we should have plenty for anyone that wants one. Also, in addition to that, if you have questions or even just a service issue for those of you that are already using Hoosier Start, you should have a card at each station that looks kind of like this. And if you'll just fill that out, you don't even have to be specific. If you'd like to just put on there in the other topics section, I have a fiduciary question, that's fine. Myself or one of our other local Hoosier Start representatives will be sure and get right back to you and get an answer to your question. Thank you all very much, and thank you, Marilyn.
Well, good morning, everyone. Thank you so much for inviting me. We're going to talk about fiduciary responsibility, not specific to the Hoosier plan, but to any plan sponsor that's offering a defined contribution plan. And I'm going to see if I can make this move. There we go. So there have been a lot of lawsuits lately on ERISA plans, which is one of the things that's really been in the news. It's also really important to know if you're sponsoring or participating in a defined contribution plan, what your responsibilities are. And there are some that are employer responsibilities, and there are others that rise to the level of fiduciary responsibilities. And we'll see that fiduciary responsibility requires that you meet standards that are the highest under the law. So who is a fiduciary? What are those standards of conduct? What are your functions? What are some common mistakes? And how can you reduce your fiduciary liability? So for one thing, we have a number of 457 plans that have multiple record keepers. And this really got started back when Code Section 457 was first enacted, because at that time, all the money belonged to the employer. It was subject to the employer's creditors. There was no such thing as fiduciary liability because it was the employer's money. And many providers only had their proprietary funds, and that's really changed. Now almost all record keepers, have an array of funds that are available. But back then, the plan sponsors would take a hands-off approach and let multiple vendors in an effort to diversify investments And just because there was no fiduciary responsibility to worry about, that has all changed. And that was never the case for 401k plans, for example. You don't see 401k plans with multiple vendors because those plans have always been held in trust and have always required fiduciary responsibility. So that's why we've seen this change over the years, and the lawsuits have really brought it into focus and have provided a lot of good lessons on how to satisfy fiduciary responsibility. So we will focus on the lessons to be learned and how you can minimize your responsibility. So employers, when you think of all the things that you do as an employer, you get to decide, okay, what benefit package am I going to make available to my employees? Am I going to offer health insurance? Am I going to offer life insurance? Am I going to have a defined contribution plan, a 457B supplemental plan, for example? So as the employer, you're putting this package together and deciding what to offer. Fiduciary responsibility attaches when you put those decisions into play, when you're administering the plan and operating the plan, selecting the investments and the providers, and ensuring fees are reasonable. That's the fiduciary responsibility. So in Indiana, you're fortunate to have an option of choosing to be in the Hoosier Start plan or to establish and maintain your own plan. And it's my understanding that some of you have done both. You offer the state plan, but you may also have another plan or other providers that you allow your employees to utilize. So today we're going to look at how the decision to either adopt the Hoosier plan exclusively or to maintain your own plan or a side plan affects your responsibilities and how you can comply with those responsibilities. So if you do adopt the Hoosier plan exclusively, you as the employer make the employer decision to offer this plan to your employees. And you do agree to comply with the employer functions under the plan. I mean, you are still responsible for deducting the deferrals out of people's paychecks, getting them into the plan on time, making sure someone doesn't start special catch-up unless they're eligible. Those things that you have to do with an employer still apply. But the Deferred Compensation Committee, as the fiduciary, relieves you of the fiduciary functions that you would otherwise have to fulfill. What you still need to do is make sure from time to time you think the plan, the state plan, is still a valuable benefit for your employees, just like you would with your health insurance. Sometimes you decide to change your health insurance vendor, for example. So if you adopt your own plan or you have a plan other than the state plan, then in addition to the employer functions of deciding to offer the plan, you have all the fiduciary responsibilities of implementing and administering the plan. And the mistake that employers make most often is not recognizing that they're plan fiduciaries. And if you're a fiduciary, you have a number of responsibilities there, which are on the screen, and we're going to talk about them in some detail. And it can be quite time-consuming, right? So since fiduciaries are held to the highest standards of conduct under the law, it's important to know who are your fiduciaries. Well, if you have your own plan, this is an issue because you are the fiduciary. The individuals that you have working on the plan are fiduciaries. Anyone who has discretion over plan administration or over plan assets is a fiduciary. It could be your trustees, members of your administrative committee or investment committee, and often that's the same committee that makes those decisions. Staff members are typically not fiduciaries, but if you have staff members that are interpreting the plan document or have discretion to maybe approve a qualified domestic relations order or something like that, if they're exercising discretion, then they will also be a fiduciary. And sometimes when I speak to large groups, I'll say, how many of you decided, you got up this morning and you decided to go and breach your fiduciary responsibility? Let's see the hands. No hands, right? That's a good thing. So then sometimes I say, okay, can anyone name one of your fiduciary responsibilities? And typically I get no hands there either, although I know some people in the audience know what their fiduciary responsibilities are. So we want to make sure that you identify your fiduciaries so that they know they don't inadvertently breach a duty they didn't realize they had, right? So the second biggest mistake is thinking that if you've selected a third party to assist you with the plan, that relieves you, the employer, of your fiduciary liability or responsibility. And of course it doesn't. The act of choosing that third party is a fiduciary function. So you may have other fiduciaries on the plan with you, for example, an investment advisor that gives advice for a fee. Those people are fiduciaries. But typically record keepers and accountants, maybe the attorney that reviews your plan document, those people are just providing you with information that you use to make the decisions. They're not exercising discretion over the plan. So they're typically not fiduciaries. So your committee, I'm going to call them a committee. Some people have boards, some people have committees, some people just have a group of people that work on the plan, that make plan decisions. And you'll see when you have the list of all the things that you're required to do, you need to select individuals that have sufficient time to devote to prudent oversight of the plan. I mean, there are standards that have to be met, but the result of those standards means there's a lot of time and effort that's needed, and many employers don't have people that they can just assign exclusively to administering the plan. So train your plan fiduciaries, educate them and make sure they know what their responsibilities are, and then document your decisions. You're going to hear document, 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 but when we get to the lawsuits, you'll see why that's so important. So what are the fiduciary standards of conduct? Well, we know that governmental plans are not subject to the Department of Labor's ERISA rules, right? But the state of Indiana does govern plan sponsors, and the Indiana statutes are very similar to ERISA. I have never seen a state statute that conflicts with ERISA. They may use slightly different terminology, but the principles are the same. And in Indiana, I've given you the code sections there in case you're interested in looking. But you do have a duty of loyalty, a duty of prudence, a duty to diversify. Those things are in the Indiana statutes, and then most governmental plans use ERISA as a guide because it's a concise fiduciary manual all in one place that you can use as a best practice. So let's look at the duty of loyalty first, avoiding conflicts of interest. I think once that you know that your primary responsibility is to act solely in the best interest of the plan participants, everything else is common sense. You have to just act knowing that that's your goal, right? To act solely in the best interest of the plan. That's where reasonable fees come in. You can't be loyal to your participants and be exercising everything in their best interest if you're allowing them to pay excess fees, right? And you can't put your own interest above those of plan participants. Now, I think it's easier to see how this could happen in the for-profit world because I did a finals presentation for an ERISA 401k plan. And when we got done with the presentation, the chairman of the committee said, "Oh, we would love to have you be our record keeper." And as soon as Empower Retirement starts buying all of its widgets from us, you'll get the contract. They clearly had their employer hat on. They wanted a record keeper who would pad their bottom line as an employer. You have to avoid those types of conflicts. So prudence. Prudence, and I'm sure everybody's heard this, the duty to act with the care, prudence, skill, diligence a knowledgeable person administering a retirement plan would use. So it's just understanding what your duties are, how the plan works, and then making decisions on behalf of the plan. And it's one of the most important duties because it comes into play with every decision that you make, right? It's more than an obligation to be competent and careful. When we look at the lawsuits, they're talking about prudent processes. Have a prudent process. And the courts have found that if you have a prudent process, you follow the process, they're going to rule for the employer every time. Indiana follows the Prudent Uniform Investor Act, and I know you can print these slides. I'm not going to go through this, but you can see here your statutes: reasonable care and skill, diversify, invest solely in the best interest of the beneficiaries, which in the case of a plan is the participants, right? So a prudent process, well, if you think about it, you have a decision to make, maybe what fund to choose. You gather the information on funds in that category. And then once you've made the decision, you implement it and then you monitor. We're going to find that monitoring and making changes is as important as the initial decisions that you make. So here's another list of just why I say, there are standards, but they're very time consuming. These are all of the things that fiduciaries have to do on behalf of a plan. Now, the state handles these responsibilities if the only plan you have is the state plan. But if you have your own plan or you have other vendors outside of the state plan, these are all of the things that you need to be doing, and you need to be doing them on a periodic basis, which is why I say repeat, right? You have to have a process in place to make sure you're monitoring and ensuring the fees are reasonable and ensuring all the plan documents are up to date, all of those things. And administering the plan is important. Sometimes your committee gets so wrapped up in selecting and monitoring the investments that they forget about plan administration. And for example, if the IRS comes in on audit, they're not going to even ask you what funds you have. They could care less. They're going to look at your plan document and look at your policies and procedures and your forms and make sure that you're operating the plan in compliance with an updated plan document. So you should read the plan document thoroughly. I always say that's a great prescription for insomnia. Those plan documents don't have a whole lot of plot, but they are important because they're your manual for operating the plan. And that's the primary catch-all for the IRS. If they happen to come in and audit your plan and they can't find anything else, they'll find some place where you're not operating exactly the way the plan document says. And we've seen an employer that got fined $25,000, not because they violated the code, just because they didn't do it exactly the way the plan document said. So selecting, monitoring, and deselecting investments. Now this is interesting because state law requires you to diversify and to monitor, and courts have agreed. This is a duty that plan fiduciaries have. And here again, the state handles that for the state plan. But we have a unanimous decision from the U.S. Supreme Court. Never happens, right? Unanimous decisions, and this is when there were 9 justices, but we have one. And this was a little bit of a nit as far as why they went to court. It was based on statute of limitations. So the plan participants sued the plan sponsor for having bad performing funds with high fees. And the plan sponsor said, well, too bad. We made that decision more than 6 years ago. And there's a 6-year statute of limitations. So since we chose those bad funds more than 6 years ago, you can't sue us. But both the plaintiffs and the defendants agreed there's an ongoing duty to monitor. So essentially, every time you should have been monitoring those bad funds with high fees, you've sort of started a new 6-year statute of limitations that you can't say that you didn't have a duty to monitor and to deselect funds when appropriate, right? So the role of the fiduciary is active, not passive. And we always recommend that you adopt an investment policy statement, and that will assist you in monitoring and deselecting your funds. Now, your investment policy statement is a governing plan document, and it really sets out the criteria that your funds have to meet to be selected in the first place, to continue to be offered, and then what happens if they fall below their benchmarks, how you go about replacing your fund. And as we see with the lawsuits, I always say the only thing worse than not having an investment policy statement is having one and then not following it. That's what gets everyone into trouble. So selecting and monitoring service providers, it's very important that you use objective criteria, establishing a regular review process. If you have multiple vendors, then you need to make sure you're monitoring each one and their performance and their fees. And hopefully you only have one plan document, even if you have multiple providers. But you need to know if you have more than one plan document, every 457 plan you have is one plan as far as the IRS is concerned. So it needs to be monitored for contribution limits. If you have 3 plans, you still only get 1 contribution limit, right? So you need to make sure that you're monitoring all of your arrangements. Document, document, document. Fees, making sure fees are reasonable. As I mentioned, this is part of the duty of loyalty, that your fees be reasonable. So you need to know what funds or fees are being charged, or you can't determine what's reasonable. And I love this, the IRS says fees must be reasonable. The Department of Labor says fees must be reasonable. The state statute said your fees must be reasonable. What's the definition of reasonable? None of those people are going to say, right? We have no definition of what's reasonable. They put that burden on you to determine what's reasonable. So we always say, you need to know what fees are being paid, and you don't have to choose the lowest cost provider. And the courts have said that's true. You need to follow the criteria in your policy statement. You need to benchmark the employers. You need to maybe have someone assist you from time to time to get information on what other plans are paying for similar services. Now, ERISA plans, the Department of Labor requires that the service provider give fee information to every employer. It has to describe what services they're providing, and it has to tell you what the fees are for those services. Now, many providers are also providing those to state governmental plans. Empower does, and I'm sure others do too. But if you're not getting it, request it so that you can see exactly what services you're getting and what the fees are for those services. And this fiduciary file cabinet, yours doesn't have to look like this one, right? We don't have many file cabinets that look like that these days with all of our electronic capabilities. But I thought about it when I was visiting a small employer in Colorado, and I'm saying, You know, if the IRS comes in on audit, because they were asking me, what do we need? I said, you're going to have your plan document, your trust agreement, your services agreement. They're going to want to see your forms. You should have all of that in one place where you can get to it easily. And one of the committee members said, oh, remember when Sally was working on the plan before she retired? She had this big filing cabinet with all those papers in it. Where is that? Find it, right? Find it. So it doesn't have to look like this, but just remember, make sure you have your documents and make sure that you have documents for every provider that you have. So common mistakes to avoid. I'm going to go through this list and then we're going to talk about the lawsuits a little bit. But as I mentioned, not knowing that you're a fiduciary. If you're administering your own plan, you're a fiduciary. Thinking that if you hire an advisor, they're going to do everything. That's not true. Assuming your service provider handles everything. That's also not true. So you also need to document your decisions. You can see this list, not knowing you're a plan fiduciary, not knowing how much the fees are, not updating your plan documents. These are all things in this NAPA survey that led the list on common mistakes that employers make. And why is that important? Lawsuits. Now, for several years, there's been a particular law firm in St. Louis that's been filing lawsuits against 401k plans. And they're pretty much the same allegations. It was a big enough plan that they shouldn't have been using retail mutual funds, right? They should have had alternative investments. They shouldn't have funds that have high fees, right? And now, just in August, more than a dozen lawsuits have been filed against universities. These happen to be 403B plans. And it's interesting because apart from 457 plans, 403B plans are the ones that usually have multiple record keepers, right? So the new allegations here, in addition to you should have used different funds or you should have had lower fees, they're saying use of multiple record keepers resulted in higher fees for these participants. Because if you think of what a record keeper has to do, they have to do all of the duties, whether they have part of a plan or all of the plan. So they have to cover the costs of the accounts and loans and distributions and QDROs and everything a record keeper does. If they have fewer participants, then the cost per participant is typically higher. So that's one of the new allegations in the lawsuits. And the other thing is too many investments, which also happens quite a bit when you have multiple record keepers because every record keeper offers a set of investments. So we're going to watch these lawsuits very carefully to see how they play out with these new allegations about record-keeping fees and too many funds. They say that results in paralysis. The participants just can't make a decision. So if we look at how you can make your life easier and reduce your fiduciary liability, there's a couple of ways. You can decide only to be in the state plan. That relieves you of all your fiduciary responsibilities, and you have to make sure you're handling your employer responsibilities. And the state plan has adopted many of the prudent practices that the lawsuits are just complaining about. They have a single record keeper. They have a limited number of investment options. They have a fixed participant fee instead of an asset-based fee. And they have institutional class shares, not retail. So those are some of the things that you need to think about when you have your own plan, because those are some of the things that are at issue in the lawsuits. So consolidating to one record keeper on your own plan is the single most effective way to do it, because that reduces all that time you have to do that whole string of things that fiduciaries have to do if you don't have to do it multiple times, right? So, and that can lower the fees and really take a lot of the burden off of you for administration. It can simplify plan design, plan administration. You have one investment policy statement. Monitoring is much easier. Participant communication and education is easier because it's all directed toward education and not sales material from various vendors. And it can dramatically lower fees. It also enhances the participant experience. There have been a lot of studies that show if you have too many funds or too many choices, employees procrastinate. They just can't decide, should I enroll? How much should I save? What investment should I choose? And if before they even get there, they have to choose a vendor on top of that, we're finding that those plans have much lower participation because there's just too much for the employee to sort through. So if you just have one vendor, then you can focus your communications on plan features and benefits. And if you provide 404C information, and this is really important, governmental plans don't know what 404C is. I say most ERISA plans have no clue what 404C is. So we've just talked about your fiduciary responsibility, and it's the employer's responsibility to choose the funds, monitor the funds, deselect the funds, but you don't want to be responsible for the individual choices that your employees make. You know, if you have an employee who's 65 and is ready to walk out the door and they put all their money into the aggressive growth fund, and that just happens to tank the day they walk out of employment, you don't want to be responsible for that, right? If that fund was prudent when it was chosen, you've been monitoring it, you don't want to be liable for the individual choices of your employees. And you're not if you offer at least 3 diverse investment options, and everybody has more than 3 diverse investment options. Once you've got that hurdle out of the way, it's a communication statute. So if you're providing easy to understand communication about the funds, about the fund managers, about the fees, about how your employees go about changing and making their investments. I mean, do I have to fill out a form? Do I have to call this number? Do I have to go online? Any or all of the above? How do I make changes and provide them with enough information to make informed decisions about their accounts? Then you're not liable under ERISA. Now, we've had a number of lawsuits that have settled, and a number that have gone through the court system. And as I said before, when the employers are found to have followed prudent practices, followed their investment policy statement, they've won those cases every time. Some employers have decided to settle just to try to reduce costs of litigation. And now we have some very good news in the Chevron 401k case. This was also brought by that firm in St. Louis. They have 24 cases, and they think they're on a roll. They're the ones that filed all those lawsuits against the universities for having multiple employers and too many funds. And this judge said they didn't prove any of their allegations. And they were saying, this committee looked at their funds and their fees, and they made changes. That's proof that their previous decisions were a breach of fiduciary liability. That's what the plaintiff said. The judge said, that proves they're following their process. They're monitoring the funds. They're making changes. That's exactly what they're supposed to do. They said you can't just allege something like that without proving that there was a breach of fiduciary duty, that they didn't follow their processes, right? It's process-driven, not outcome-driven, and that means you don't have to select funds that go up a minimum of 3% every year, or you don't have to have a stable value fund, or you don't have to have a money market fund, or that you can't have a money market fund, right? You need to follow your investment policy statement. So this is very good news, and we hope it really slows down some of the litigation that has been brought, because she said you can't just allege these things, you have to prove a breach of fiduciary liability. And one of the things that they complained about was a money market fund. They should have had a stable value fund. And the judge said their investment policy statement allows for money market funds. Where in ERISA does it say you can't have a money market fund? Where does it say you have to have a stable value fund? Well, they used revenue sharing to pay for the record keeping fees. So, are the fees reasonable? There's no per se prohibition against doing those things. So here again, this is very good for employers. If you're following your processes, you're going to be found not to have breached your fiduciary responsibility. And here's Todd's contact information if you have questions. And I'll ask for questions now if you have any. Ah, everybody wants lunch. Okay, one question.
Can you hear me now?
Yeah.
It's up really loud. Okay, I just had a question. I wanted to thank you for talking about fiduciary responsibility. I think half of us wouldn't even know how to spell that word if it wasn't up there on the board. But I was reading through all the slides, and I was still having a hard time how if we chose Hoosier Start, how that would eliminate our fiduciary responsibility, because on slide 6, under employer responsibilities, you mentioned that we have the responsibility to make sure that the plan is administered prudently or prudently administrated. And I'd like you to talk just a little bit about that.
Okay, that's a good question. The employer sets the benefit package. And one thing that I often use as an example of your employer responsibility versus your fiduciary responsibility, I think it's easier to think about with a pension plan. A traditional pension plan, let's say everybody gets 2% of their highest 3 out of 5 years, whatever the formula is for your pension benefit. Let's say it's 2%. And the employer decides we're going to knock it down to 1.5%. When could a fiduciary do that? A fiduciary has to act solely in the best interest of the participant. So the fiduciary could reduce the benefit. Arguably, a fiduciary could never terminate a plan. When would that be in the best interest of the plan participants? It's not the fiduciary that's doing that, it's the employer. So on slide 6, what I mean by that is, just like with your health insurance or life insurance, you look at the provider that you've chosen and you say, yes, I'm going to stick with XYZ healthcare, or no, I'm going to change to ABC healthcare. That's the type of decision you'd be making as the employer with regard to the benefit package. I, the employer, have decided to offer a 457B plan. I have, as the employer, have decided I think it's in my employee's best interest to be in the state plan. A year from now, do you still think that's a good choice as the employer to stay in the state plan? Or do you think it would be better if you had your own plan? Those are employer decisions, not fiduciary decisions. Once you've decided you want the state plan, the state administers the plan. If you decide you want your own plan, then you have fiduciaries at your employer that handles the plan, that administers the plan, and they're the fiduciaries. Yeah.
How would you get rid of someone you already have, or can you? We've had another vendor for many, many years, and so if we went to the state plan only, what would happen to the people on that plan? Would we have all the ones we have, or?
Well, and that's a decision that you get to make, but under state law, you could terminate the other plan, roll the money into the state plan. There are a number of issues if you want to do that and ways that it can be done.
Would it be like PERF where if there's unfunded something or other that we'd have to pay a bunch of money to
There's
do it?
no unfunded liabilities or anything like that with the 457 plan.
Okay,
No.
all right, thank you.
You're welcome. Okay, well, thank you so much.